Well, good morning, everyone. It's 10 o'clock, and we've had a number of people join, and people are still joining. But I'll start with some of the preliminaries. First, I'm Dick Kelly. I'm a senior partner with Oblon, and I'm a member of the chemical practice group, and also the life science practice group. And I've been in the patent business, well, for a long time, more than 50 years. And my objective today is to try and provide everyone with a methodology for determining whether or not a claim is patent eligible. And you might ask, how can I do that since the Federal Circuit doesn't seem to be able to come up with a consistent deal? And basically, what I've done is I've looked at the Supreme Court decisions, which go back, if my math is right, about 170 years, and have been shockingly consistent. And so what we're going to do is look at what's happening, try to figure out why we're in this mess, and then what we can do to develop a methodology that's going to work for us. Now, the first thing that's important to remember here is that when we're talking about patent eligibility, it's the claimed subject matter that's got to be patent eligible. If you read a lot of the comments that people write about the patent eligibility decisions, quite often what they're complaining about is that the patentee didn't get patent protection for his invention. But in many cases, it's because he didn't claim it correctly. It's not enough that you have the invention described in detail in your patent. It's not going to do you any good if you've engaged in overclaiming and find that you're claiming a product of nature or one of the judicial exceptions. Now, why do we need a methodology? Well, first, the Patent Office has provided some extensive methodologies in its Patent Office guidance. But the Patent Office guidance is not law. And under the Administrative Procedures Act, it is not supposed to be followed by the courts because it didn't go through the normal process, rulemaking process. Furthermore, it's not supposed to be applied by the Patent Office against the public. Tell that to the examiners. So guidance is quite different from the rule. Rules bind everyone. Guidance binds only the issuing agency. Now, the key thing is at the bottom of that slide is it's not entitled to Chevron deference. Chevron deference is a Supreme Court principle, which is under attack, where the courts are supposed to give serious consideration to the agency's interpretation of the laws under which it operates. And the deference is only not given if the agency is wandering outside of the rules set forth by Congress. Patent Office isn't entitled to that. In fact, the first district court case under the current guidance that came out, Judge Brinkema of the Eastern District around the street from us pointed out to the attorney who was telling her that she must follow the Patent Office guidance. A rather curt comment said, no, it's not a rule, and we're not following it. And they lost the case, needless to say. You don't tell a judge what they must do. You try to persuade them what they should do. Now, it's patent eligibility is important because it's a question of law. That means you can make your motion under Rule 12b-6. If you're right that the claim is not patent eligible, the case is over. A final decision is rendered on that because it's a legal question. You don't have trials to decide legal questions. You have trials to decide question fact. Now, because it's a question of law, there's no presumption of validity. It gets tried again from the beginning. That's why 12b-6 is used so much by defendants. Now, the presumption of validity applies only to fact disputes. So the challenge for the patentee is to make sure he survives the 12b-6 challenge. And we need a methodology because the clients are paying us to get patents which are eligible. And we need to have a prosecution strategy, which is not only going to get us a patent, but it's going to get us a patent that the courts will consider as being patent eligible. So we need a strategy that allows us to navigate the Patent Office guidance and the Federal Circuit decisions, which are different. Like Judge Brinkham of the Federal Circuit has said, it does not follow the Patent Office rule guidance. It applies its own law without regard to that guidance. So when we're prosecuting for the Patent Office, we've got to realize that we've got multiple audiences we're dealing with. One is the patent examiner. If you don't get the patent, you don't have to worry about the rest. The other is the Federal Circuit. And the third is the public at large, which would include potential licensees or potential infringers. These people are going to look to see, do they think the claim is patent eligible or not? And so we have multiple audiences which are using this for different purposes, and there's at least two different standards we have to comply with. Now, we need to be able to provide advice to the clients as to whether or not they're going to infringe on someone else's patent. Is that patent claims patent eligible? We've got to have a basis for opinions regarding patent eligibility, whether it's our client's patent or a competitor's patent. And the other thing is that this issue cuts across all technologies. There is not a separate methodology for chemical, a separate one for mechanical, and a separate one for electrical or system claims, computer implemented invention claims. It's the same methodology for all. Now, to be able to develop a methodology, you have to understand what the source of the patent problem is. Now, it's easy. Oops. When you look at it, the first thing, you can eliminate the Supreme Court as the problem, despite the fact people may think otherwise. The Supreme Court, in decisions by the Supreme Court sitting en banc, since the mid-19th century have been remarkably consistent, much more consistent than any other part of the law. Prior to the mid-19th century, Supreme Court justices riding the circuit also provided opinions on questions that we would today call patent eligibility. By the time of our Civil War, the courts had looked at abstract ideas, they looked at natural laws, and naturally occurring materials. What the Supreme Court did not use in the 19th century was the concept of judicial exceptions. They didn't think they were exceptions. They thought they weren't included. Now, if we look at the Federal Circuit, it certainly is one of the sources of the problem. The Federal Circuit is notorious for not following its own precedent. Each panel thinks it can do its own thing. If you look at Association of Molecular Pathology, what you had there is the Myriad case. It's directed to the isolated DNA. And the Federal Circuit, in its decision, which was reversed by the Supreme Court, said isolated DNA exists in a distinctive form. But previously, the CCPA, which always sat en banc, and its decisions are binding on the Federal Circuit by the Federal Circuit's own decision-making, found purified uranium and vanadium not patent eligible, even though more ductile than the natural form. So you get the Federal Circuit ignoring its own precedent. And that creates a problem for us because it's precedent that you rely upon when you're doing decisions. Because we're a common law country and it's court decisions which really shape the law. Now, the other problem is the Federal Circuit doesn't provide uniform guidance in any area. If you Judge Albright of the Western District of Texas complained mightily in Health Discovery about the Federal Circuit's 101 decisions. He laid 3 of them out in his opinion and said he couldn't understand why the 3 decisions were different. And this is a problem. If the Federal Circuit is not consistent, then we're left really at sea without a compass. And unfortunately, that's where we find ourselves today. And the Federal Circuit is great for not following its own precedents, as I said. In the Macro case, which was a patent eligibility case, the Federal Circuit, in order to save the claims from both patent eligibility and non-enabling disclosure, read limitations into the claims, and they reversed the district court's holding a lack of enabling disclosure, and also use those same limitations to decide that the claims were a patently eligible subject matter. So we're sitting here with a court which goes off and does its own thing. Each panel seems to think that they're free to ignore what the previous panels have done on similar cases. Basically, the Federal Circuit likes to say patent cases are fact-specific, which is partially true, but not totally. Now, the Patent Office is also at fault in this whole thing. And the fault there is that examiners, in many cases, fail to apply the statutes, 35 U.S.C. 102 and 112A. If you look at all of the patent cases where the claims were found to be patent ineligible, you'll find that they were subject to being rejected either because they lacked an enabling disclosure that was commensurate in scope with the claims, or the claims weren't novel. If you look at the Sequentum case, the district court decision very much went through what was going on. If you read the patent, you'll find out that the exemplary claim, was broader in scope than the enabling disclosure. It's not my opinion. The inventors told us what their invention was. And as we'll see when we get to that, it wasn't in the representative claim. Now, failure to reject for anticipation or obviousness. The Mayo case involving a therapeutic window, patent to a therapeutic window, the patentee admitted that doctors had performed the analysis, the positive steps in the claim, in the past. What was lacking was the limitation on minimum concentration in the blood and maximum concentration in the blood of a metabolite. But the steps were the same. It was, and almost everyone agreed, it was rejectable over 102. Patent Office didn't see it that way. So we've got Mayo out there as a decision that's caused by the patent office. Now, perhaps the biggest source of our problem is ourselves. When you get into this business, one of the first things you're told is the claims, you have to draft claims broad enough to prevent design arounds. That's pretty good advice, except that, like all rules in the English language, there is an exception. Because if you do that and your claim involves one of the judicial exceptions, almost inevitably, you're going to wind up preempting the judicial exception in your claim, and therefore make a claim, presumably preventing a claim which is patent ineligible. So it's important that when you're drafting claims where you have the judicial exception involved, that you think very carefully about the breadth of the claims. You've got to make sure that you don't preempt that judicial exception and prevent others from using it to make new inventions. Now, the problem here is that we're forgetting the history underpinning patent law. Patent law is, in the United States, common law. While we talk about 35 U.S.C. being a code, it's not really a code. It's basically a sketch that the Congress gives to the courts, and it's the job of the courts to fill it in, to decide what's a printed publication, what's an enabling disclosure. We don't get that guidance in the code. It comes from the case law. And we as attorneys have to remember what the history is. And the history of our patent system began with the statute of monopolies in England in the early part of the 1600s, where the king had taken to making money by selling patents for the exclusive right to sell certain products in geographic regions in England. The problem was what he was giving the patent for was things that were already in the public domain. And he finally crossed a line when he gave a patent for the sale of salt. And what was the reaction was Parliament took that ability away. It had to be new in the realm. And that really is the beginning of patent eligibility. Something that's not new is not patent eligible. Something that is claiming things in the public domain, like natural laws, like naturally occurring substances, and abstract ideas. They're all out there for everyone to use freely. You can't put a monopoly on them. Now, the Supreme Court has, in the Mayo case, said quite clearly that patent law must not further inhibit discovery by monopolizing natural laws. Now, they use monopolizing. I prefer preempting because monopolies generally have a bad connotation in the United States. And certainly right now with the shift in Congress to being anti-patent in a sense, where it comes to drugs patents, preempting sounds a lot better. And the Supreme Court in Mayo this wasn't new law in 2012. 1854, in the Morse case, had decided the same thing. So what we have is the Supreme Court telling us what the deal is. You can't preempt natural laws and ultimately abstract ideas. Now, claims which cover the only commercially viable way of detecting a natural phenomenon carry a substantial risk of preempting all practical uses of it. And that was just a comment by the district court in the Sequenum case. In the Sequenum case, the district court didn't just talk in terms of the claims. It looked at what was the effect of the claims. In Sequenum, the invention was a method for detecting and isolating from a pregnant woman's blood the cell-free DNA from the fetus, which could then be analyzed for genetic defects or color of the baby's hair, whatever, and doing it without being invasive, just a simple blood test. Prior to this invention, the only way you could look at how the fetus was developing was really by getting amniotic fluid, which means you're doing a very invasive procedure, which could result in a spontaneous miscarriage. And quite often that did happen. And unfortunately, many of those miscarriages were of normal fetuses. So this was a major improvement. But what the court was concerned about is the way the claims were, nobody could develop or use the CFF DNA without infringing the claims. And this was especially true at the time the patent was applied for. By the time this was before the district court, there was a non-practical way of doing this. Unfortunately, the Federal Circuit did not look at the preemption discussion because it really is the driving force behind the judicial exceptions. Now, the MPEP does recognize that preemption is the court's concern. They do it in Section 2106.04H. But they didn't consider it sufficient basis for deriving their guidance because they looked at the preemption of the natural law and naturally occurring substances, abstract ideas per se. They really did put it in the context of the claimed invention, which is the second step analysis. Had they, we might have a much more useful guidance from the Patent Office. Now, it's important to note that preemption doesn't mean preemption of all uses with a judicial exception, but all uses in the field of the claim. So that's a key here. Preemption here is narrowly defined as being what's the field of the claim. The methodology is fairly straightforward if you think about it. Claim's going to be patent ineligible if the claim scope preempts the judicial exception. And if you're talking about an abstract idea is one which you cannot implement without infringing the claim. Another way of looking at an abstract idea is that it's simply an idea and not an invention. It's a desired objective without the means being claimed to achieve that objective. Now, preemption is present in all patent ineligibility cases, although it's not often articulated by our Federal Circuit or the other court, which is unfortunate. Now, how do we navigate the conflict? Now, we have a problem between the courts and the USPTO. The USPTO, as I said, has rejected, the courts have rejected the USPTO's guidance because it wasn't promulgated in accordance with the Federal Administrative Procedures Act. But we still have the problem of navigating between the courts who don't give us a whole lot of guidance and the Patent Office. Now, one of the things to keep in mind when you're prosecuting is your prosecution is going to be looked at by several people. One is going to be the patent examiner. The other is, if it's valuable, by a court, or possibly by a court and third parties who want to see if they can defeat the patent. Now, the PTAB in its 101 decisions has taken an interesting approach that I've noticed. One of the things is they look and apply the Federal Circuit and often the Supreme Court law to reach an initial conclusion. And they then turn to the Patent Office guidance to see if it matches up with them. And they find it does. A few board decisions reverse the order. But the key thing with the PTAB is they apply both standards. And that's something that we should do in prosecuting before the Patent Office. We know that what the examiner is going to look at is a PTO guidance, but we're putting in front of them two reasons. Because you're trying to show after the patent issues that this was done correctly under any standard. Now, one of the things what I'm going to do next is use some examples to test preemption as being the appropriate way. And we're going to apply it to a diverse group of cases. Now, the first two cases I'm picking are American Axle and Sequentum. And I'm picking them because there were a lot of things that were done right by the prosecuting attorney, and then American Axle by the litigating attorney. And Sequentum, prosecuting attorney did some things right, but the litigating attorney did not. In both American Axle and Sequentum, we had claims of varying scope. If you think about an inverted pyramid, we had a very broad claims, and we had some narrow claims in both cases. In both cases, in the Sequentum case, Sequentum trial counsel ignored the fact that he had claims of varying scope and picked the broadest claim as representative of all the claims. This is unfortunate because the Federal Circuit noted that Claim 24 was quite different, but they refused to consider it separately because they had said Claim 1 was representative of all. In contrast, in American Axle, whoops, I'm getting ahead of myself here. Oh. In American Axle, the litigating attorney argued for both claims, the broad claim and the narrow claim. He lost on the broad claim and succeeded on the narrow one. Now, this slide is the first part, the preamble, which is long, where both the broad claim in American Axle, which was Claim 22, and the narrow claim, which was Claim 1. Now, Claim 22, this is the part of the claim which differs from the narrow Claim 1. And all it requires is you give a hollow shaft member. Now, this was a dry line system. This was a drive shaft. And what the invention was is they were trying to make the drive shaft lighter, fuel economy. And as you made it lighter, you had problems that you would get vibration in shell mode vibration or bending mode vibrations. The shell mode was axial to the drive shaft, and the bending modes was perpendicular to the axis. In Claim 22, you can see that all they provide for is a hollow shaft member. It says you tune it, mass and stiffness of at least one liner. You stick the liner into the shaft member, and then it says the result is that the liner attenuates the vibrations. The problem with this claim is it doesn't tell you how you're tuning it, what the tuning objectives are. It doesn't tell you where you're putting the liner in the drive shaft. Nothing about how it's achieving its result. You could say this was broader than enabling disclosure because the disclosure has specifics. Or you could say that it was patent ineligible. And of course, the defendant here, NEPCO, called it patent ineligibility because he wanted to avoid a trial. Almost succeeded. Now, Claim 22, according to the defendant, was Hooke's Law. And the question is, how can you apply? Hooke's Law is available for everyone to apply. But how can you use Hooke's Law to reduce the vibrations without infringing the claim? There isn't any way. They don't tell you how they did the tuning, what you tuned to, or anything about the liner or where it's placed. This is really a claim to what the invention does rather than what it is. And that's one guideline you should keep in mind. The treatises in the late 19th century, Robinson on Patents, specifically noted that courts don't give patents or not for what an invention does, but rather what it is. And while we can use, to a limited extent, means plus function language to get function in there, you still have to be defining what the invention is, not what it does. Now, in contrast, Claim 1 for the same position, after the preamble, talks about hollow shaft member, the tuning, and you tune to attenuate one line or tune to attenuate at least two types of vibrations, positioning the liner within the shaft member such that you have the liner configured to dampen shell mode and bending mode vibrations, and even set minimum mounts. Now, what the Federal Circuit was looking at, they said Claim 22 was patent ineligible, but they said Claim 1 was patent. They didn't say it was patent eligible, but they said you could not find it patent ineligible under Rule 12v6. Now, in the decision, they considered Claims 1 and 22 separately. Claim 22, as I said, they said Hooke's Law, patent ineligible, preempted the usage, the law. When they looked at Claim 1, they said this has some interesting limitations. The tuning requirement and the positioning. Court ignored the limitations on the degree of damping. What they looked at in positioning, you're going to say, well, claim doesn't say how you position it. Well, remember, the claim isn't what has to enable the practice of the invention. That's the job of the specification. So in a claim construction, you would be construing these phrases based on the description and the specification. That construction very well result in a claim which is patent eligible. But the key thing here was the court was unwilling to say whether it was limited to Hooke's Law and nothing more, or it was a eligible invention. That required the case to proceed to discovery and ultimately trial. In other words, the patentee got the opportunity to explain what was going on and why it was patent eligible. And one of the things we all know is if you are in litigation, most litigation settles. So here, American Axle has probably a good chance of winding up with a settlement. And this is basically talks about preemption. Claim 22 used the Hooke's Law without specific structures. Here, the key thing is the claims of different scope were presented and argued separately. And because of that, American Axle will be able to use Claim 1, use claim construction to salvage Claim 1, whereas it gets nothing with the broader Claim 22. Now, sequenum has the same general, the patent's claims has the same general structure as for the claims in American Axle. We have a broad claim, claim 1, and we have a narrower claim, claim 24. Now, what happened in this case is the litigation counsel picked claim 1 as representative of all the claims in the litigation. Now, the Federal Circuit noted that claim 24 appeared to be different. Didn't say how it was different, but it was different. And it said, but we don't have to consider that because claim 1 is representative. Now, we take a look at claims 1 and 24, you'll see that claim 24 is longer than claim 1, which means it has some additional limitations. Now, the invention here, according to sequenum, was discovering where in the blood serum sample you were going to find the CFF-DNA, the nucleic acid of fetal origin, cell-free. If you look at claim 1, there's nothing about where to look. And again, when you were looking at a blood sample, you segregated, you separated into fractions by centrifusion. It doesn't tell you where to look. And if you read the first paragraph of the patent, it says all of this was old. All of what's on claim 1 was old. And what their invention was the fraction that they picked, which is in claim 24. The method comprising removing the nucleated and anucleated cell populations and then doing the amplification on the remaining fluid. That was defining where to look. And you can see language highlighted here. So claim 24 is claiming the invention. And if you read the patent, you'll understand that claim 1 was admitted in the body of the patent to not work, not enabled. People had tried it, people had failed because they didn't know where to look. Claim 24 told them where to look. And you can say, well, gee, maybe the litigation counsel picked claim 1 as representative because they needed it for infringement. No. Everyone was practicing the technique of claim 24. Sometimes greed and avarice is not good. Now, the district court, in its discussion, went off on preemption. But again, what the district court was dealing with was claim 1 as the representative claim. Now, claim 24 does not preempt CFF-DNA because the removing step allows for possible design around. You're not foreclosing people from looking at a blood serum sample differently to find CFF-DNA. Now, what happened here is the good work the prosecution counsel did got tossed aside because litigation counsel didn't consider what he was doing in terms of preemption. If you read the briefs that were filed by sequenum, the briefs harp on very strongly the invention being where to look. Problem was that wasn't in the claims that the claim 1 they selected as representative. Now, one of the areas where the Federal Circuit has been fairly consistent, although it doesn't give a consistent reason, is in diagnostics. As a general rule, if you have a diagnostic claim, Federal Circuit seems to be holding them mostly patent ineligible. Now, Athena is interesting because it tells us, shows us the importance of claiming the invention as opposed to the broadest possible claim you can get. Here, this is a claim for diagnosing for neurotransmission development disorders related to the presence of particular kinase in a mammal humans. Now, it's myasthenia gravis, which is a significant neurotransmission disease humans suffer. And like all diseases, while you can't cure it, you can treat it. And the sooner you treat it, the more likely it is the patient will be able to live a semi-normal life. This claim is claiming detecting that by detecting antibodies to an epitope of the kinase, which I've abbreviated as MuSK. The problem is that's a natural law. If you've got the kinase, which is your problem, then you will have the autoantibodies. There's nothing in this claim which distinguishes it from what's occurring in nature. The only thing that you're doing is you're detecting the presence of something that's naturally there. The claim preempts all methods of detecting the neurotransmission or development disorders. You can't get around it. Now, this is a claim that they probably should have tried to get, because the invention here was their discovery that people who tested negative for this acetylcholine receptor but had symptoms of myasthenia gravis were testing negative because in their particular case, it was the kinase that was causing the problem. So what the invention was, and it's just as described in the patent, is that you first run the standard test for acetylcholine receptor. And if that's negative, but the patient has symptoms of myasthenia gravis, you go to the second step and detect, see if there's MuSK, there's kinase present in the blood serum of the patient. Here you're not simply looking for the presence of MuSK, you're first performing a first step, acetylcholine, then the MuSK. You're going to say, well, again, isn't this going to be narrow and somebody can get around it really easy? Not so. 80% of the people who have myasthenia gravis are going to test positive for acetylcholine. Only 20% are going to test positive for MuSK. So if you do the MuSK test, like in their claim 1, 80% of the positives will be missed. So as a practical matter, you always have to do step 1, then step 2. Those are not natural laws. You're doing more than the natural law. The key here is to think about what is the invention. The invention was the recognition that 20% of the false negatives were really positive myasthenia gravis, and developing a strategy to allow you to identify that subset of the population. It's not found in any of the claims, and they didn't put any claims in to this kind of step. Now, this claim is what I would suggest. It's pretty simple, but you can have other wording possible, but the key is that you've got to do step 1 and then step 2. And doing those 2 steps is not in nature, it is something more. Now, coming to The last one is collective technologies. Now, this is an abstract idea. Well, it would fall into the abstract idea case if it was an abstract idea, of structuring a peer-to-peer network. And the defendant here argued that this was an abstract idea and therefore not patent eligible. And what they did, this is the claim in collective technologies. I would suggest not trying to read it on the screen. You might go blind or at least hurt yourself. But what this has is several limitations in it, which take it out of the abstract idea realm. One of the reasons why it's not an abstract idea is what I've highlighted in black and the second highlighted in red. This is a system. And what they have in here is a specific system. Now, it's very broad because it doesn't tell you specifically the devices that are going to do everything. It tells you how it needs to be arranged, how it is to work. Oops. This is the claim with the highlighter. And you can see, one, it's got to be a peer-to-peer network, multiplicity of peer nodes. All peer-to-peer networks don't necessarily have that. And the peer modes are distributed outside of the controlled networks or content distribution networks that are included. So this is telling you how it's arranged. The red is how you do your content segmentation. Now, there's no preemption because alternatives existed. There were other ways of doing the distribution using controlled networks or content distribution networks, the things that were excluded by the method. Now, naturally occurring. This is one of the fascinating areas. What is naturally occurring? And how do you decide if something's naturally occurring? Well, the Myriad case really helps us and also gives us more insight into what the Supreme Court's thinking. The Myriad case involved a claim to a DNA segment. Now, DNA, of course, is naturally occurring, but it's naturally occurring as a complete structure with many thousands of amino acids. The DNA segment is less than the full thing in nature, and it is terminated at either end of the segment with groups which are not found in nature. That is, it's not terminated in nature. So if you look at it from strictly a chemical point of view, it is different from how it exists in nature. So the question is it naturally occurring? The Federal Circuit had said no. The Supreme Court had a different view. The first problem that it has is a segment contains the same sequence as the naturally occurring DNA, just separated from the rest of it. Now, the problem was that the claims focused on the genetic information in the segment, not on the chemical changes. And the claims, according to the Supreme Court, preempted the use of the genetic information. This would be a different case if that same segment now had utility to create a vaccine, for instance, a vaccine against COVID. By removing it from the full-length DNA and terminating it, you would have given it a new property which it doesn't have in nature. In other words, if the same concern is in sequenum, so what do you have to do? Well, one of the things is you have to look back one here. You have to evaluate what is going on. What happened here is Myriad didn't care of composition. They focus only on the genetic information. So what do? Well, the first thing you've got to do is you've got to evaluate the presence of judicial exception. You've got to follow Alice. If you do that, and you say, yeah, there's a judicial exception in there, it's a law of nature, abstract idea, whatever, you then have to ask yourself, is it possible to design around? If yes, then the inquiry's over. Does it preempt the use of the exception in the field of the claims? If it does, you've got a problem there. Is it directed to or obtaining information? If you answer no to question 1, patent ineligible, answer yes, question 2, patent ineligible, question 3, patent ineligible. Information is not patentable. So that's what we have. Now, one other thing is, if you look at Myriad and what was going on, if that same segment, as I said, had been useful to create a vaccine, then it would be, its use as a vaccine would be patent eligible because the segment remains free for other uses of the information in it. Anyway, thank you. And if anyone has any questions, you can email me at the address we gave. And thank you very much. And everyone have a good day.